Okay, so welcome to this morning of the Antitrust Conference. I'm very excited to be here in person after 3 years, but I'm even more excited to have the chance to question these fantastic panels of one of the fundamental questions of what we're going to do next, i.e. what are going to be the criteria that we think are the right criteria to apply the antitrust. So, as I said, I have a fabulous panel that starts with Alden Abbott, who is a senior research fellow at the George Mason and has a long history where he served as a Federal Trade Commission General Counsel from 2018 to 2021. Dora Mackey, who is the Principal Deputy Assistant Attorney General of the Antitrust Division of the U.S. Department of Justice. We have Fiona Scott-Morton, who needs no introduction, but is the Theodore Nirenberg Professor of Economics at the Yale School of Management. And you have Zephyr Teachout, who is the Associate Law Professor at Fordham Law School. So with this panel, one thing I learned over 2 years of Zoom is that to make things entertaining, you have to ask a lot of short questions and demand short answers. So what I will do, I will try to apply this learning on the field. First of all, there are a lot of people that are following. And number two, it's early in the morning, we want to keep people awake. So let me start actually with you, Fiona. Since I learned that if you speak first, you're going to be asked first. So I think that there is one aspect that I think we all agree upon is that we want an antitrust law that is administrable, okay? So each one of us has one criterion that we think we would like to use. So what I would like to ask each one of you, if you were queen for a day, or some people are actually king for a day, what criterion should you use? And why? In the sense, what led you to determine that's the right criterion? So, Fiona, why don't you start?
Okay, so first I will do my disclosures using the AEA standard. For the last 3 years, I've worked for a variety of tech companies, Apple, Amazon, Microsoft, Epic, HTC, a variety of healthcare companies, Bard, Cigna, Pfizer, and of course I have worked for governments in the past and continue to do that. So that's a good question. I think the criteria, I'm going to pick one criterion, would be just protection of competition. And I think Nancy said it really well yesterday. That's what we do in enforcement. We look at competition, and that encompasses all the things that you think it ought to, that is to say quality, innovation, price, anything that is in the demand curve. And if you're doing that, then you're not limiting yourself to a set of behaviors. You don't have to write a list of these behaviors are illegal. You say, I'm protecting competition, and then whatever the firm invents to do this year that's different, that tries to stymie competition, is going to fall into that category.
Fantastic. Dora, what is your view?
It's a great question. And actually, let me ask, can you guys hear me well?
Yeah, they adjust it.
Okay, awesome.
So don't worry.
So I tend to agree with that, and I suspect you're going to hear the same thing from everyone on the panel, right? The goal of the antitrust laws is competition. I should say that I am kind of uniquely situated relative to everyone else on the panel because it is actually my job to administer the antitrust laws on behalf of the United States. And so I would have deep concerns about federal antitrust agencies, or courts for that matter, reading values other than what is on the face of the statute and consistent with the legislative intent of the statute, which is promoting competition. And so I think the proper question when evaluating a merger or a business practice is always whether the conduct is simply part of a competitive process or whether the purpose is actually to suppress or even destroy competition. And it's a prohibition on your request for short answers. I want to be clear. I think that we as lawyers are not very well suited to assess welfare and surplus effects and transfers, and I would be very concerned about the kind of central planning that is attendant to agencies and courts making determinations about what is efficient and maximizing efficiency and welfare?
Thanks, Luigi, for that question. By the way, I should say views are my own, not necessarily those of the George Mason University or Mercatus Center. I would turn to, first of all, I agree the thrust of Doha's remarks, having been both in the Antitrust Division and the Federal Trade Commission at different times. I like what Herbert Hobenkamp wrote in his one-volume abbreviated treatise in 2020, and I think it's important because judges look to this. They look to Hobenkamp probably more than any other authority. The goal of the antitrust law should be maximum output that is consistent with sustainable competition. Output includes quantity, quality, and improvements in innovation. High output favors suppliers, including labor, as well as consumers, because job opportunities increase when output is higher. Subject to some exceptions, it also favors small business, dealers, and other intermediaries in the distribution system. And high sustainable output is also conducive to economic growth. And we can discuss that some more. I'll leave it at that.
Zephyr.
Good morning. Thank you for having me. It's an honor to be on this panel. I never update my bio. I am actually now senior counsel at the New York Attorney General's office. My views do not reflect the views of that office. And some time ago, I became a professor, but I keep forgetting to update that.
I was wondering, I think there was something funny in that thing, because anyway, thank you for reminding me.
Small, and my views do not reflect the views of Fordham either. So I think we're missing some basic questions, which is that any antitrust standard should conform to the rule of law and democratic legitimacy, which means antitrust should be grounded in congressional intent, and if we want to overturn those laws, we can, but it is not up to either the judiciary or academic economists or academic lawyers to overturn laws. We only have judicial supremacy in the case of unconstitutional laws. Second,
Zephyr, if I may say, we're going to go to there, but at this moment, I'm asking you, if you are the queen for a day, what would you do? It's not what is in there and would interpret, but your ideal choice.
Right. So, and I will say that one feature I think overlaps, which is legibility. I think legibility and public legibility is a key feature of any good antitrust regime. So I think the core goals of a strong antitrust regime are freedom and fairness. And an antitrust regime should serve to promote a decentralized economy in which power is decentralized so that workers can thrive, small businesses can thrive, and importantly, people can be free from private tyranny. And the one piece that I haven't heard so far, but I think is key, not just in our legislative history, but in our current public demands and in my own view, is that antitrust plays a uniquely important role in protecting us from private forms of illegitimate power in the political sphere.
Okay, so this is quite interesting. Thank you for bringing some diversity, because if I understand quite correctly, the three first members of the panel, they pretty much converge on an idea that the role is protecting competition, and Zephyr has a broader role. Now, before we go into this broader role, I would like to stick for a second at this idea of protecting competition, because as economists, we are about trade-offs, right? And so what does it mean really to protect competition? How do we resolve? Because one of the challenges is we have to delegate to judges, with all due respect for judges, but they're not particularly competent on the little detail of economics. So we need to give them a rule that they follow to what is right and wrong. So if you are, again, in the spirit of Queen of a Day, you can legislate, you have your protecting competition as the sort of goal. How do you go and give them a rule that they can follow without a PhD in economics? So are you willing to trade off consumer surplus for efficiency? Are you willing to trade off value constituency, workers or consumers? How do you implement this idea of protecting competition? And more importantly, does it mean protecting I know this is a no-no, but protecting competitors? But if you are down to 2, protecting competition does mean protecting competitors, or not? Fiona, why don't you start?
I think that the rule that we have on the books is a good rule. I would say that one of the things that is most troublesome about the way we enforce antitrust laws today is the worldview and the values of the people who are on the courts. These are people who I think trust corporations, favor corporations, trust the monopolists to innovate, and put those values and beliefs over the needs and the welfare of consumers. So let's look at the American Express case. That's a case where by having high costs for using an American Express card, the merchant has higher costs, has to raise prices in the store, and so the people paying cash and debit are funneling money to the people with American Express cards. So it's a business model that funnels money from the poor to the rich. The opinion talks about the entry of other high-fee cards as an efficiency. The Chase Sapphire card is an efficiency. A two-sided market definition is a backdoor way to allowing efficiencies out-of-market efficiencies to be included. So would the question you asked me, if I had a good answer for it different from protecting competition, would that be enough to convince a Justice Gorsuch that Amex and Discover compete? I don't think those word choices really matter. I think if I say protect competition and then go into court and explain that Discover's trying to enter and they have this way of entering that's a low-price strategy and they're competing with Amex, and the court says, oh, no, we like our Amex cards, they work really well, go home, that's not, we're just in a world where the value system of the people hearing these cases are not in line with protecting competition, and I don't know what you do about that. I don't think messing around with the vocabulary and the instructions helps a lot.
Actually, Napoleon faced a similar problem when he was running France. He had a bunch of judges that were ancien regime. They were not listening to what the word of the revolution was. And what he did, he invented the Napoleonic Code. So I think that there is a chance, it's called statute, and you force by statute.
No. The thing you're talking about is the bright line rules, which is what the Germans do. Let's make a list of all the things you're not allowed to do. Box, 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 box. That's fine until the economy changes, till we invent a new technology. Then we have to legislate a new list. Now, I don't know about you, but my observation of the U.S. Congress is it doesn't legislate very much. So if we have to wait for them to write a new rule about the internet, it's going to be the year 3000 before we have a rule about the internet. So if you go that route and you want the itemized list of things you can't do, you have to be in a world where the list can be updated regularly to keep up with GDP and what's happening in the economy.
So maybe I'm putting words in your mouth, but what I hear you saying is that your ideal rule is not implementable in this world.
Correct.
Okay, that's a pretty dramatic statement. I hope you have a little bit more hope for us.
I don't know if I have hope, but I have comments. What's remarkable about the list approach is that the Clayton Act actually does that, right? It prohibits a long list of practices. And somewhere along the way, and I think we can debate the reasons why, courts and agencies just kind of disregarded them for reasons that, again, we can talk about. There's no predatory pricing enforcement, right? You never see exclusive dealing enforcement. You never see, Section 8 interlocking directorate enforcement, right? And that it's incumbent on the agencies to find those cases. But going back to the legislative history, Bork himself was actually skeptical of judges and imposed a view of what the antitrust laws were designed to protect that, again, suffers from some illegitimate borrowing and one-sidedness and other well-documented problems. But we've largely ignored this history and ignored the fact that he had comments about efficiencies. Well, I'll stop there. I think there's more to say, but I don't want to take the conversation in a completely different direction. So,
Okay, and maybe I come back to you.
yeah.
Alden.
Well, thanks. There are standards out there. There's a question of rules as standards. But for example, the structured rule of reason, which is found in such decisions as Judge Ginsburg's three tenors decision, gives judges a path for looking at a claim of competitive harm, potential efficiencies, and deciding whether they're credible or not. It gives you a structure. The Microsoft opinion of the full D.C. Circuit in 2001 also gives you such an approach. So I think they can be refined. There can be a greater understanding of efficiencies. But I think judges can determine whether some efficiency claims. I've sometimes heard it said, "Oh well, they blindly accept efficiency claims." I don't think that's true. There are a number of efficiency claims. For example, in the three tenors case, a free riding claim, there was in the Microsoft case, judges said no, they did not accept those claims. I'd also say that it's interesting that Noah mentioned exclusive dealing. I agree, but the Federal Trade Commission brought a number of cases, including a one in the Court of Appeals under the chairmanship of Joseph Simons, which centered around anti-competitive exclusive dealing. So I think the idea that it hasn't been enforced, perhaps less at the Justice Department. The last few years I followed it less closely, but I can tell you that there were a number of settlements and a lot of complaints where exclusionary exclusive dealing was alleged.
No, I understand, and we
case is
come
this?
down to what the courts are doing now, but I want to really try to get, you have a principle you read that was actually quite complex. So how do you give a rule for people to implement the principle you described?
Yeah. Well, I think I'd go to the rule of reason. I look to Hovenkamp, and I look at as I say, as described in such cases as three tenors. There's actually structure, point 1, 2, 3, 4, that judges can follow. And I think perhaps if there were an argument, say, well, more judges need to follow this. And by the way, this is how we interpret it.
What are the
Yes.
1, 2, 3, 4 that the judges should
Okay,
follow?
well, one, is there a claim that this particular practice is likely to have some anti-competitive effect, restrict output? And in the short form rule of reason, as in the three tenors case, there was a claim that short-term price fixing on one record label was to support the release of a new record label of the famous three tenors. That was all right because it was just temporary, and basically the argument, the FTC said no, there's certain claims, so there's harm from price fixing, A. B, is this the sort of thing that's ancillary to a gain? And the FTC said no, price fixing of this sort is never going to be acceptable as ancillary. You can give a quick look, and unless some other efficiency claim is brought up, you can dismiss it. But generally, you have the first response, and if there is a legitimate efficiency that is credible and that cannot be achieved by some other means, then you go back to the government and say, well, there is perhaps a minor efficiency here, but there's a lot of harm to competition elsewhere. So it's a structure. Judges are not in a game. They're not able to measure surplus or the size of surplus transfers. They need, as Justice Breyer said, a set of rules. And again, I could, for purposes of the audience, and then finally, as I said, the final step is saying, you don't have, if you have a quick look, it ends. The quick look, this is not a credible sort of response, then defendant loses. If it's credible, and then you go really through this four-step process. So again, it's not perfect, but I think it's better than any alternative we have right now under our common law system. And there are elements of it. It's not exactly comparable, but certainly under European jurisprudence, the search for there are elements of that. I just say look at, for instance, the most recent Intel decision, the General Court. Again, it's not our structured rule of reason, but I think you can. What you need is better understanding of what are dismissible, credible efficiency stories and not. Perhaps that's one of the problems.
Can I respond to
Wait,
that? Actually, yeah. So I think that to put in context of what Alden just said, which is all very useful, more than 95% of rule of reason cases tend to be found in favor of the defendant, right? When we look at our Section 2 jurisprudence, right, when private cases go to the courts, there are a number of exploitative and exclusive practices that don't have a corresponding measurable output effect, right, that we all recognize harm competition and harm trading partners, but nonetheless are upheld by the courts. And so I think you hear us all talking about the value of competition, but I think when the rubber meets the road, the central issue is that the narrative content of the antitrust law does not appropriately track what is an antitrust violation, right? And so there might be multiple reasons for it. Maybe judges are importing certain views about the legitimacy of business conduct, the credibility of certain efficiency stories, but the bottom line is that we have an antitrust law that is nowhere near measuring modern antitrust problems in the U.S. economy.
Okay, we're going to come back to you, Zephyr, but I want to follow a little bit on this thing because I think it's very important. Because if I understand correctly, what you're saying is the problem is that when the rubber hits the road, the system is such that cannot really enforce anything. I'm putting words in your mouth, but and I'm sorry for that. But it's sort of however, again, maybe it's my formation as a continental European guy. This problem is common and is solved very often by shifting the burden of proof or making sort of a disproportionate costly for one side to prove the case. So if we had a very simple rule that say, if you do X, Y, and Z, we presume that this is inefficient, and you have to prove efficiency. Wouldn't that make it much easier to achieve what we seems that all of us want to achieve, which is a system that promotes competition?
So I think there's a role for general reform, no doubt. But if you look at the research on rule of reason cases, they actually don't fail at step 2, where you start measuring efficiencies. They fail at step 1. I mean, courts are quite actually not able to detect harms, right? And that is concerning.
No, I understand, but if you change if courts cannot assess harm, then and you say we presume harm, and then you have to prove the opposite.
I think it would certainly be an improvement over our current circumstances.
No, but it could overdo it, Fiona.
Yeah, I mean, then you have to have a list of practices that presume harm. And there's going to be lots of, let's take exclusive dealing. If the Yale School of Management were to have an exclusive arrangement with a coffee shop in New Haven, there's many, many coffee shops. There are many, many businesses in New Haven. That's not going to hurt competition at all. So what do we say? Exclusives are presumed anti-competitive, and then any other coffee shop can bring a lawsuit, and then the Yale School of Management has to say, well, it's fine for us to be doing this. So you would generate some interesting knock-on effects with this kind of presumption, so you have to think carefully about how you write them.
Of course.
But I do generally agree with you 100% that shifting a lot of burdens to the defendant side to say, look, you're the firm, you have the incentive and the ability to explain what you're doing, what the efficiencies are, why it's good for competition, is a great solution, because those firms are aware of why they're doing things, and it's perfectly appropriate, and making money from it, so it's perfectly appropriate and incentive compatible to have them bear the job of saying, here's why it's good. So I think anything along those lines would be super helpful.
Zephyr, can you comment on this one? We come back on the bigger picture because I'm the idea, but can you sort of...
Yes, no, I mean, the reason I'm eager to get in is I have a proposal here. Like, I have something to put on the table. I have an answer to your question.
Good.
The answer to your question is that trying to enable competition without competitors is unadministrable, and we've proven it. I don't think there is any administrable regime in which you can say that you can successfully enable competition over years without actually having competitors. So then the response is, and administrability, I take administrability sort of like a public administrability. Like if you can't clean the toilets because you don't have enough plumbers, it's not administrable. And the billions it would cost.
I like the analogy.
Right, so it's like actually not administrable. And the cost of bringing in the economic experts to bring every single one of these cases to prove the lack of competition is too great, and so therefore it is fundamentally unadministrable. So I think there's a two-step reform process. One is a structural approach, which is we need competitors. Maybe 6 significant competitors would be a useful way to think about it. And in showing concentrated markets, we need to make sure that judges know they can take direct proof of market power and not just indirect proof. And second, the list approach. And the list approach is extremely useful. I'm looking at tying, refusal to deal, exclusive dealing. And this, Fiona, is where the economists can play a critical role in crafting the statutes. But I do worry about statutes that only shift presumptions, given the correct diagnosis that Fiona has of the courts and the sympathies that the court have, as opposed to carefully crafting statutes that do not have economic efficiency as an affirmative defense. So I think that we should move to a structural approach, and I also, because legibility is so critical, a business torts approach. Thinking about these per se rules not in the rarefied language of antitrust, where we talk about per se, which is an illegible phrase for the public, but business torts, which is a legible way of thinking about it.
But your structural approach relies very heavily on having very clear definition of what a market is, right? And with technology, these things are shifting. So who is in the digital payment market? One day, Facebook is not, the other it is. So how do you define the number of competitors in a marketplace?
So 2 things. One is, and I wasn't clear about this, some of these business torts only apply to dominant firms, and others would apply across the board. So, sort of a non-compete might apply across the board, and others would just apply to dominant firms. And in those dominant firm cases, your question is the most relevant. And that's where I think it's important to provide multiple means of showing dominance, not merely the market definition approach, which you rightly say is also inadministrable in the sewage sense. But allowing for direct evidence, including pricing power and other term-setting power outside the borders of the firm.
But so you feel that when, let's say, Amazon came to town with the bookstore and Barnes & Nobles was kind of kicked out, you should protect Barnes & Nobles because, or Borders, because we need to have enough competitors in bookstores, for example.
So I'd need a few more facts in that particular case, but yes, we need competitors, and I think all the efforts to, I just keep going back to Jan Eickhout's magnificent set of slides when we talk about purpose. These 3 very legible, by the way, slides from yesterday, is that we have failed at a macro level to have a decentralized economy. We have failed workers and we've failed small businesses. And trying to, in individual cases, figure out the potential efficiencies of mergers is a losing game. So we must continue to enable the structural, start to re-enable a structural approach.
Alden, yeah.
Interesting comments, but first of all, I'll throw out a few facts. But first, I'd say that the case of Amazon is interesting because one can argue about self-preferencing issues of that sort. But it seems to me that there's a lot of evidence out there that huge consumer surplus was realized by Amazon's being able to build its own distribution system, provide an options of relatively inexpensive goods. And during the pandemic, when people were not physically shopping, its broad platform allowed huge transfers throughout the economy of products that were being purchased. And I think lots of consumers benefited. Had Amazon been prevented from developing the way it did, there would have been a lot of harm during that period. I'd also say,
I completely agree with you, but if I understand correctly what Zephyr said, so what? We have harm here, we have harm there, we trade off a harm here and harm there, and it's important to preserve competition long term. There are some collateral damages, and Amazon not expanding is a collateral damage. Am I reading correctly, Zephyr, or not?
I think, and I know you pushed me off on this, but I think these are fundamentally political decisions.
No, I don't want to push you. I'm going to come back to that, I promise.
Yeah.
So,
Okay.
Yeah.
And so I guess I am not as persuaded about the scientific accuracy of those who see the surplus and fail to see the harms. And again, when you look at the last 30 years in terms of what has happened in concentration and the destruction of entrepreneurship and the destruction of small business, not destruction, but real radical decline, it suggests that we have failed to capture those harms. So I am also arguing that the current model of measuring efficiencies fails to capture some of the great losses that come when we allow concentration.
Yeah, but I am with you on that.
Okay.
However, I think that we should be honest and say,
Yeah.
look, we cannot achieve the perfect solution. There are trade-offs. And what I read from your statement is, if we have a little bit less efficient delivery at home, but we have more choice and we have more intellectual freedom,
Right.
that's
Yes,
worth it.
right.
So we are willing to trade off those things.
Yes.
Okay. Alan, continue.
Yeah,
Sorry.
I just
But I don't think the trade-off, I reject the premise, but in theory,
I think just, there's dangers in sorts of comparisons. However, I think it's interesting that I think 19 of the 20 large platforms, innovative platforms, that I think without question brought huge consumer surplus, were started in the United States, not in Europe. Why is that? Does it have something to do with the fact that for all, and I have lots of European relatives, love Europe, but it has a more regulatory system. It has a civil law, a competition law structure that tends to be, much more rigid than the common law structure as it's developed in recent decades. I say take it for what it doesn't prove anything, but I think it's interesting. Also, the idea that judges do not take into account competitive harm. They're ready to buy off efficiency. Just a few quick statistics. Maybe they should have won more litigated cases, but 2010 to 2019, Justice Department, 7 wins, 0 losses in litigated antitrust cases. Federal Trade Commission, only 1 loss in the last 20 years in litigated hospital case. After they straightened out the analysis of markets and hospital mergers, fantastic success. Lots of 67 of 68 FTC pharma merger complaints settled through divestitures, and there's an argument about that, but there's a lot of evidence that pre-merger competition was maintained, and
we're coming to what the courts have done. I'm just trying to see to what extent we can or cannot converge on something that is implementable, okay?
Yes.
And I'm starting to lose hope, so maybe, Fiona, you can
Yeah.
restore my hope, okay?
So let me just make one remark about the trade-offs issue. I do think it's very important for the antitrust laws to be democratically accountable. I think that the kinds of examples that we're talking about here are a little bit dangerous if you are an elite person. I love walking to my downtown and buying from my independent bookstore and buying a croissant from my independent bakery and going to the boutique and finding a baby gift for somebody. But I am high income. And if we are going to have antitrust laws that impose that shopping environment on people who are low income, working 2 jobs, having difficulty supporting their family, wanting a low price for their shampoo or whatever it is they're buying, and what we're saying is, no, actually, we are going to impose high costs on you because we want to keep alive a business that is struggling, that's something that might not be popular with the bottom half of the income distribution. So whatever we do in this regard, I think it's quite important not to take the viewpoint of the high-income people and impose it on the low-income people.
I completely agree. Just one second. I completely agree that we should, the final trade-off should be done by the legislator because it's a political trade-off. I think that we agree. But the bigger part of the panel agree on protecting competition, but it seems that does not agree on a rule that implement that. Because you are basically saying it's impossible to implement that, so we should give up. Or the closest thing I get is we have a structural approach, because a structural approach makes it easier to implement, and the structural approach has collateral damage. Nothing is perfect, and so we economists might be asked to design the least damaging structural approach. But at the end of the day, we are trading off. If we have a list of stuff and we need to have enough competitors for a market to be competitive, we are slowing down a bit Amazon in order to have the competition working.
Yeah, so I think that we have been saying for a number of years now this issue about, so the reason I think it can't work is because of the existing judicial stock of people that we have. And if they can't enforce the antitrust laws the way the people want the antitrust laws to be enforced, then we will move to a world where they don't have so much input, because we'll have a list. And here's the list, and do you have this characteristic or that? And if so, then you can't merge or something. And that's I think, what you're pointing us towards, and I think that's quite right. That's what's going to happen.
But sorry, this is not, I understand, a Republican or Democrat, because Steve Breyer was appointed by a Democrat, but it was not very different in this spirit. So what kind of judges do you want to implement your criteria? If you were queen for a day, you could also choose your judges. Who would you choose?
Well, again, let's look at the kinds of reasoning that we've had in recent cases like Sprint, T-Mobile, Qualcomm, American Express. Those reasonings they're judges who can't see that American Express competes with Discover, who can't see what the MFN is doing, who think that the entry of really high-priced cards is a good idea rather than the entry of Discover with a low-priced card, who think that we really need 4 competitors in mobile phones, and the way to get that is to merge 2 of them and then sponsor an entrant who's going to ride on the back of another one for 7 years and somehow grow to have 30 million customers. I mean, these are not market realities. And I don't know how you find judges who are more in tune with market realities. The judge in Sprint T-Mobile, a case in which I testified on behalf of the states, was very worried that Sprint would have low quality. And by that, he sort of meant that there wasn't going to be service at the top of the ski resort in Wyoming. And there's just a lack of understanding that the modal Sprint consumer doesn't go skiing in Wyoming. She lives in the Bronx, and she takes the subway and she visits her sister in New Jersey, maybe, or something. But the ski resort quality is just not in the utility function. And maybe we could let the market sort that out. If she did care about ski resort service, then Sprint would provide it. But she doesn't, and that's why Sprint isn't. And so there's just not this attention by courts to actual evidence of what's happening.
But sorry, my impression is that judges don't have such a sophisticated view of economics, and all the stuff that you're saying is stuff that we economists fed to them. And it's just that all this efficiency reason, etc., they're all straight from IO books. No?
I don't know what you mean. Yeah, I mean, of course quality matters, but what I'm saying is different kinds of quality matter to different people, and we could let the market figure that out. If there are 4 choices, then firms will respond.
As Tommaso was saying yesterday, with our on the one hand, on the other hand, we always give another hand to basically block the enforcement. Because if rule of reason is there is enough of a one hand to say that there is efficiency, you stop it.
Yeah, well, that's why you have to read the documents to
Yes,
find out
but
what
isn't like
people are
the
doing.
field has favored this other-endism, I don't know how to term it in English, that anything is possible, and because anything is possible, a combination between rule of reason and anything is possible is nothing is enforceable.
Anything is possible in theory, but that's why you have to be disciplined by the market you're talking about, and the documents and the actions and the prices and the qualities of the thing you're enforcing.
But Fiona, if you can't imagine a judiciary that does this, then why don't you approach?
No, I can imagine it. I thought that the question was, we're stuck with what we've got.
No, I told you, they are queen for a day, you can appoint your judge. Tell me what a judge who is not like a PhD in economics.
Judge Coate in New York, who wrote the e-books opinion, that opinion I highly recommend just for its enjoyment value, and especially the footnotes, which are super snarky. This displays a tremendous grasp of market realities and gives a very nice reading of where competition is manifesting itself and where it's blocked. Yeah, there's lots of good judges out there, just not enough.
Dora, do you think that we have enough good judges, at least by Fiona criteria, to implement this idea of protecting competition, or we should do something else?
So let me take a step back and say what's so fascinating about some of the bad opinions that Fiona identified, and there's AT&T Time Warner, there's Sabre Farelogix, there's T-Mobile Sprint. I mean, they're everywhere, right? There's Amex. It is not a political determination of who is a good judge and who is not. I think we all know we have a hardworking judiciary, and Article III judges bear out the task of figuring out what is an antitrust violation, and that is a difficult job. That being said, I think the principal issue is that they are taking in evidence of harm, right? They are paying attention to market realities, and then it's like, don't believe what you see if you cannot back it into some model that they believe is the right thing to do. They are not, ruling in favor of plaintiffs, and that to me is a problem. And again, I used to be a history teacher, and so I always kind of revert to history because I think it's really interesting. I talked earlier about how Bork really did not trust judges, and so he writes in 1963 something like, and I quote, he disliked the existence of a, quote, unelected, somewhat elitist, and undemocratic judicial institution. And so what we get is a set of rules that are outcome determinative, and I don't think Judge Bork is solely to blame for the problems that I think have intensified over time, but I think the combination of a failure to take in market realities and outcome determinative tests has crippled antitrust enforcement in the United States.
Alden.
Thank you, Luigi. I think, again, let's look at the few numbers. There seems to be an assumption that judges are just not willing to rule for plaintiffs, or, why is it in 2020 you had, just look at the FTC, 31 merger-related challenges, 9 suits, 12 consents, 10 abandoned. What does abandon mean? It means that the parties thought that they would lose, likely, before a judge. What about a vertical merger, NVIDIA-ARM? That was abandoned, and it raised some difficult issues. It wasn't horizontal. It involved some issues of innovation and quality. That was abandoned by the parties after the FTC filed a complaint. So I don't buy the notion, very honestly, that somehow plaintiffs always lose, and these judges aren't. Clearly, in abandoning these transactions, some of these parties are saying, hey, if this is litigated, we're not going to win. So they must think that the judges are likely to rule against them.
So I think they're saying that the judges might reject some transaction, but we know that the only cases that are brought up are the ones with some chance of winning. And so there's a huge selection, and the judges determine that selection. So nobody's on a suicidal mission. So if you know you're going to lose a case, you're not going to bring it. And if you know that judges are already decided in the other direction, you're not going to bring the case. So I think that the fact that there are a few cases that still the plaintiff win, or at least the abandoned transaction, I don't think that proves that the judges have gone too much in the other direction. Remain to be determined. But I want to go back to, because I postponed Zephy for a long time, so I want to go back to this issue that is very dear to me, that is the issue of freedom. And to what extent you actually implement that, because I am the first one to say I'm worried about concentration. Mostly, actually, even if I'm an economist, mostly for democratic issue, not for economic issue. Now, this, of course, brings the question of a trade-off to a different level, okay? Because if it's difficult to trade off consumer surplus with other things, what about freedom? Because we'll say, I'm not willing to sacrifice anything for freedom because it's such a value, and so as a result, we're here as cavemen, and we don't take any technology, etc., because we want to be free. So how do you design such a trade-off, and such a trade-off that has some chance of being implementable?
Thank you. A few weeks ago, Amazon floated an idea of an internal chat function. I don't know if you saw this, where they banned words like plantation, slave, restroom, and union. And it's not clear whether they're going to implement this. They wanted to have a good vibe internal chat.
Isn't that what Twitter does on a regular basis?
But basically, I use that as an example of the way in which it is an implausible position. It is an incredible and insupportable position to say that market structure has no relationship to political freedom. As I think the most recent report I showed that 1 in 6 Americans believe they have been either seen or been retaliated against at work for political reasons. It is implausible to suggest that concentrated markets don't change the dynamics of fear and speech in politics. And I just say this to just make sure that we're all on the same page. So there's 2 possibilities. One is that antitrust accidentally creates freedom, sort of as an externality that we don't make as a purpose. And the other is that we, in fact, evaluate the success and failure of our antitrust regime in part based on whether or not it enables a free society. And those measurements are not under the lamppost. I don't know if John is here, who is John de Figuera, but who has done a lot of work sort of under the lamppost in politics and measuring impacts and how much impact money has. But the truth is that political freedom cannot be measured under the lamppost, because that experience of the worker who is scared to speak, or the chicken farmer, speaking of Chairwoman Khan's initial stories, a decade ago, who is scared to speak because he is afraid of the distributor, those stories are not going to be measured. And that's an additional reason why we need a structural approach. Because even if you had a level of scientific certainty that we don't have, even if you had an administrable, cheap mechanism of determining efficiencies, you still would then have a company-town approach towards politics. And that's just unsustainable. And so I think a structural approach is an additional core reason. But I don't think that we should, as important as it is, the great work that AELP did on showing how concentrated industries are more heavily engaged in lobbying, I don't think we should only rely on those stories, because we know that the company-town model and the oligopoly-town model affects speech and freedom in ways that can't be measured.
No, I completely agree, but I don't think you answered my question.
Oh.
How do you implement it? Okay?
Yeah.
And what are the trade-offs?
So I think I've already given you my vision. I was queen. I have a structural approach. And
Okay,
I have a
so
list.
you're basically saying we need to have 5 sort of firms in every market, and that will guarantee sort of freedom. And so
Look, the guarantee of freedom also depends on public financing of elections, on protections.
I understand.
But
We're not
it's
trying to fix the
we're not
entire world
everything.
based on antitrust alone.
But antitrust has a significant central role and always has. And I do think that is...
And the way you solve it is by having number of competitors in a market defined in some
structural
way.
approach
So
using
then
number of competitors
here's a
or
question.
concentration or direct effects dominance.
Right. So here's a question. Let's say the firm says, you've defined the market wrong. You say there's only 2 firms in our market, but actually there's 10. And then that goes in front of a judge. How does that work?
So I think the way it works, and look, I don't think we can get rid of all of the costs of litigation. We're not done. We are trying to narrow them, though, so the plumber doesn't cost $1 million. And you and Bill were talking earlier about the incredible cost and difficulty of these cases. We're trying to solve that. So, but you say you can also use direct effects, showing the term setting capacity, other mechanisms, really being very clear to judges that they can use direct effects as well as market structure. And then so I think you have 3 different models, significant competitors, direct effects, along with our current.
Okay, so we know where Zephyr sort of lies here. I want to ask the other people. Let me define as light Brandesian, somebody who is willing to sacrifice some economic efficiency to promote a more democratic system, and hardcore Brandesian, somebody who's prepared to sacrifice all economies of scale to promote a more democratic system. So we know where Zephyr is. What about the rest? Alden, where do you fall in that category?
Well, I'm not sure. As I say, democratic system is very important. I don't very important. I'm not sure antitrust is the right instrument.
So
However,
what is the
let
right
me
instrument?
know.
What is the right instrument?
No, I mean, I think, for one thing, we can get into it, elections, other things. I mean, this is something in the political sphere. I think there's a real danger when one starts injecting the political sphere into antitrust. I mean, there is inherently policy issues.
Sorry, let me give you the scenario that is not so out of fantasy. Imagine that 6 weeks ago, when we started the war, when Russia invaded Ukraine, the dominant search engine was Yandex, the Russian search engine, and the dominant social media, instead of being Facebook and Twitter, was actually VK, which is the Russian social media. Don't you think that the dynamic of the war would have been dramatically different?
I don't disagree. No,
Okay,
I
so
certainly
if you
imagine
agree
that's
with
right,
that, you agree the fact that there is a massive
Yeah.
influence of the people who decide, because the reason why we can search war and not special operation is because it's Google, it's not Yandex. The reason why we had Zaleski that could show the people who were killed in Bucha is because it's actually Google.
Yeah.
In that case, Google and Facebook were on the right side of history. But I don't want a system that depends on one crazy billionaire to be on the right side of history.
Well,
because most of the
yeah.
time, they're on the wrong side of history, and you, cannot trust them. So I think that it's very important to consider that there is a political impact of monopolies. Now, you can say, to me, efficiency is everything, and I don't care, and I rely on the electoral law to fix it. But you cannot deny that there is an impact.
Yeah.
With this, please.
Well, let me point out that Richard Epstein, not unknown to this university here, and a classic liberal, has argued that you might treat. He's raised the idea that you might be able to view the major platforms as public utilities. So they have to post. That there's some constraint on their posting of views, and they may have to post all views. I'm not sure that's right. There's some First Amendment arguments back and forth, but there are some other First Amendment scholars who say they're a limited public forum. They may not have the full ability to censor ideas. So I think we have to explore those sorts of ideas. They're not antitrust ideas, and I agree there is a potential platform, serious problem. But I don't see how antitrust is difficult enough to come up with the right answers, applying a number of economic tools in very difficult cases. Once you start going into these other areas, socially important though they may be, antitrust is a good tool, but it's limited. It is not the way to solve society's ills. There are other tools you need to look at.
I understand that if you're saying, I want to save the environment, antitrust does not seem the perfect way to do it. But the issue of disproportionate power is not something remote to antitrust. In fact, you can say, and I'm not a legal scholar or an historian, but you can say that going to the founding of the antitrust, that was essential to the antitrust. Now, you can choose to say, look, we fail so much on what we're doing that we don't want to take a bigger role. However, sort of Fiona said that we can't do anything. And maybe by choosing a different path, the one that Zephyr is pointing out to, a structural approach, we can do better on both dimensions. But you're saying no because we don't want to sacrifice the efficiency element. Am I right?
Yes, and I agree with that, but I think the real problem is I don't think it would work well. I think it would, trying to get antitrust with its, unless you totally rewrote the statutes and totally trying to get antitrust with its instruments it does a limited purpose. Let's use it for the correct policy instruments to advance these other very important purposes, whether environmental law for the environment, for example.
Okay, Doa, where do you stand on this range of light and hardcore Brandeisian and no Brandeisian at all?
I'll sidestep the labeling for a moment. So I actually just want to make sure I understand your point, Alden. Are you saying that you favor regulation to rein in some of these tech platforms?
No, I'm not. I'm not saying I favor economic regulation. I'm pointing out that, look.
All regulation's economic, right?
Well, there's certain, again, I'm not endorsing that, but there may be other ways to deal with the First Amendment issues raised by platforms. For example, Richard Epstein argues you may be able to do that, and yet he doesn't believe that platforms should be economically regulated. I mean, for example, there is a difference between campaign finance regulation, environmental regulation, which deals with a negative externality, and traditional public utility regulation, where you had long-run declining average variable cost curves. I do know the term, good point, Doha, that the term regulation is freighted, and I'm not necessarily endorsing that. I'm just saying that scholars are looking at a number of ways. Now, if you were to come back and say, well, there's no way we can deal with this problem, turn to antitrust, I don't think we're at that point.
So to answer your question, Luigi, I think it's fundamentally unserious to believe that if you focus on competition, that the second order or third order benefits won't promote social, political, and democratic ends, right? And so the core question is not what political values should attach to antitrust, but there's a recognition that is long held in this country that if you focus on the rivalry between firms, right, there are all of these other attendant benefits. And so I think about the legislative history of the Sherman Act. I think about Northern Pacific Railway, right, where the Supreme Court says the Sherman Act was designed to be a comprehensive charter of economic liberty aimed at preserving free and unfettered competition as the rule of trade, and then goes on to say that there's all these like price and non-price benefits, and quote, while at the same time providing an environment conducive to the preservation of our democratic, political, and social institutions, end quote. And then on the back end, it says, but even were that premise up for debate, the value undoubtedly laid down by the statute is competition. And so I will end where I started, which is to say the goal of antitrust enforcement should be competition, and we shouldn't import values about trade-offs or business efficiencies, which again, I know that Senator Sherman was deeply skeptical of.
I think you brilliantly sidestepped my question, but let me not let you go so easily. In the sense that it's true that you're absolutely right that if you focus on competition, this will trickle down. So there is a part of trickle-down economics you might like. But when you go and trying to implement this stuff, then you cannot ignore the potential effect. In the sense, if the choice is between preserving competition for innovativeness and having my staff deliver at home very conveniently, I might choose having the staff deliver at home very conveniently. And it says I'm not that worried about reducing the number of competitors, let's say home delivery. But if the choice is that this will lead to one guy deciding basically what we see on the screen and et cetera, then I might feel very differently. And to be honest to Brandeis, I think that the original idea of Brandeis, which is actually, in my view, quite interesting, is that you cannot really have a democratic system if people cannot make a living on their own. Because we all agree that if you are all employees of Amazon, we cannot have a democracy, right? Because Amazon will rule. And even if you go to the electoral booths and you go through the motion, etc., it will be all fake, okay? Now, I'm not saying we're there, not even that close, but also not far either, okay? So, you can be, I think legitimately, you can be a hardcore Brandeisian and say, look, I want to preserve the ability of people to make a living without being part of a large conglomerate. Because only those people have the freedom and can fuel a democratic system. And if that's the case, I need to be very tough on breaking down large conglomerate at big cost of economies of scale. After all, that's for a different purpose, is what the Chinese do. The Chinese say, we really care about the Communist Party leadership, and we're happy to sacrifice all the benefits of this technology because we want to make sure that the Communist Party will rule for the next 100 years. Okay? So I don't think that that's a crazy assumption. And particularly in the implementation, you need to have this trade-off. You can't hide. And so if you really value those elements, I think that the structural approach, which I don't love, but it seems like much more feasible, in practice. So are you going that direction or not?
I think Fiona wants to answer this.
I think, Luigi, that there's a way to square this circle, but
Fantastic.
I would have to be queen for a day because, or for a long time actually, because what you have to do is have really vigorous antitrust enforcement all the time. So in your dystopian future, there's a monopolist that we're all working for who somehow has the best product and the cheapest product and the best service for years and never messes up and gets every technological wave right and so on. And in my experience, that's not really true. So look out at the big platforms. There are antitrust cases against them. They're 10 years too late. If we were really good at enforcing, we would not have Facebook with the market power that it has now. We would not have an ad tech stack with the market power that it has now. So I think that if you could get the enforcement to be really excellent, this problem that you're pointing out, which is a real problem, and I sympathize with it, would become much, much smaller than what we're looking at now. We have messed up badly so that we find ourselves in this situation, and I think we probably are going to end up with regulation rather than antitrust enforcement, as the Europeans are showing us. But I think perfect competition, like markets everywhere with competitive outcomes are inherently inclusive because there's a big diversity of preferences and technology keeps moving and different people want different things and you end up with competition.
But actually, your dystopian view of a large firm that does everything right and remains on top for many, many years seems to me pretty close to Amazon, because Amazon has been extremely successful and innovating, and we, as business school and business advisors, etc., are helping actually Amazon to get it all right for the near future. So we are going the direction of Amazon controlling the world, being super efficient, because that's and then what you do?
Okay, then I pass a law saying if your corporation has a market cap greater than 3% of GDP for 4 consecutive quarters, you have to divide yourself in half.
Wow, so we are for a structural approach. Okay.
But that's not, but that's,
what you like.
but I'm not counting competitors, right? It's just that's a very simple rule where you just, divide.
We're all in favor. Okay. Do I have to? Yeah, I think that I'm having a great fun, as you can tell, from asking this question, but I think that I want to open up this fun to the public. So why don't we do that? Yes.
I have my way of squaring the circle. It's a very modest proposal, but I would like the panel to tell me what they think. And so the proposal has several elements, but it's quite simple. So structure does matter. I do believe that. But the proposal is what some people call a rebuttable structural presumption, which would apply both to mergers and to conduct. So the structural presumption is that you define quickly some market share, some size parameters, there are proposals about economic dependency. You can have a whole array of indicators. And there you also work around the standard of proof. So you don't require a very high standard of proof to the regulator. So that's respond to some of the question, what if it's not 3, it's 4, it's 5, etc. It's imperfect, but it's very pragmatic. It has one advantage, which I've seen in practice. It saves a lot of resources on the agency side. So the cases I've seen, really, the consultants have an amazing firepower, and there is endless discussion about the market definition, etc., and it burns a lot of resources. The enforcers get tired. They never consider the substance, because then they just give up. Okay, this is the structural presumption with a low standard of proof. And then there is the rebuttable part. So the firms can still show that they really need that merger, they really need that behavior, that conduct, etc., to make people better off. You can refine it, but it has to be tangible effect, which is good for citizens, for consumers, and you can define, etc. And there, you can also perhaps adopt a different standard of proof. So they really need to prove it according to the bar can be put to a different level. Surely the economic consultants will start also, but at least you deal with data, with documents, with something. You really hands-on the meat of the case instead of some very esoteric discussions about the markets, what is a market, etc., etc. So this is the bulk. And to that, I would add also, to respond to some of Fiona's points, a system of safe harbors. And you can adopt the opposite. If instead you're small, etc., I don't care, do whatever you want. So those things, those coffee shops, it's not true. You have a list of actions which are bad, but only for the big firms, but for the small. So why is a system like this unconceivable? Or maybe I'm too naive. I don't have a legal expertise, but it seems like something that tries to, to put some of the good aspects we talked about without being too discretionary, etc.
I think Senator Klobuchar's bill does some of what you're saying, Tommaso.
I think it would be substantially better, but the rebuttable part creates a lot of the problems with our current judiciary that Fiona is talking about. And I also want to be clear that I agree with Fiona that we can do more enforcement. That I have a queen vision, and then there's also enforcement here. But I actually think the rebuttable part is a significant problem given our current judiciary, and a significant potential problem in general. It could do that in theory.
It
but
goes
what
to
we see
those
in
values.
practice
Sorry,
is-
can I just
Wait,
say,
I'll
it goes to the
just-
values. I'm just helping you answer him.
Yeah.
He says it's a rebuttable,
Yeah.
and it goes to the values of the judges. What are they going to listen to?
Yeah, what are they going to listen to? And the sort of the central planning problem that Doha was talking about earlier, I think it's a very deep cultural tendency to central planning that is going to be hard to dislodge with merely a shift to rebuttable, although it would be preferable.
Steve. So this is touching on something you actually said, Luigi, and the notion of some minimal income, some ability to earn, to participate in the democratic system. If we're talking about universal basic income, I see how that fits into that conversation. If we talk about fixing health care so that every American has access, or for that matter, every world citizen has access to health care, I see how that pushes things in the right direction. If we're talking about education, high quality education for free, so that when people read dumb shit on the internet, they're able to apply some critical thinking, that is something that would move the needle in the right direction. I don't see why antitrust is the tool to do those things.
Actually, since I'm the moderator, but you asked me the question, I'm not sure that I buy into the system, but I see the logic of that you don't seem to see. So let me try to explain. I think that Brandeis, as, by the way, some of the ordo liberal in Europe, had this agricultural view that if you own your piece of land, you basically can survive no matter what. And so you're a true free man. And part of the reason why the Founding Fathers, there are other reasons, part of the Founding Fathers were limiting the vote to people with land is because they thought that only with a piece of land you could be a free man. Because if you are dependent on somebody else for labor, for your income, you are somewhat influential, okay? Now, clearly, I'm not trying to go back to the bucolic period of the past. This is inconceivable. But I see this concern. I'm trying to map this concern into the 21st century, okay? And it is true that in the old days, there are a lot of professions you could survive without being part of a big organization, etc. Today is much more difficult, okay? And so the question of what this has to do with democracy, impact of democracy, I don't think is trivial, and I don't think is something that has nothing to do with antitrust, because the way I see antitrust is about power. I know that as economists we want to try to remove the word power from the vocabulary, but antitrust is about power, and economic power is political power. And if you are an employee in a company town, you don't have democracy, right? Because you can't, even if you go to the electoral booth. Unfortunately, and here I'm touching, there is Francis Fukuyama, so I have to be careful, but the political scientists in the United States have equated for a long time democracy with free and fair elections. Okay? I think that's a narrow view of the world, because in a company town, you can have the most fair election you want and free, but if people know that there is a big stick at the end of the table, they're going to vote in one direction. Okay? So I am concerned about that, and I don't have a solution, but at least I'm sympathetic to this line of argument. And you feel free not to be sympathetic, but I think it's not a crazy argument, and it's not outside of antitrust, because antitrust is about power.
So
If you're a spectrum worker,
Sorry, please.
So I think that the comment is interesting, right, about whether antitrust can promote those goals. But I do think that bad mergers and concentrated power can actually harm those goals, right? So Chair Khan and I had the privilege of doing a listening session a couple of weeks ago, maybe last week. Time is a construct, obviously. And it was about the effects of mergers in healthcare. And we heard over and over again about how different classes of workers were harmed by different transactions in healthcare. And I think others have talked about the incredible work of Ellie Prager, who's visiting at the Justice Department, about the effects of mergers, hospital mergers on workers. And so we know that benefits get reduced, right? The DOJ brought a case many, many years ago about collusion between physician residency programs, right, where they paid less in terms of like student loan forgiveness, right? And so it seems like if a failure to enforce the antitrust laws can harm all of those things, then it stands to reason that actually enforcing might promote it, right? And that's not to the exclusion of better tax policy, better labor policy, and all of these things that are vital to the proper functioning of our country. But I don't think it's fair to say, again, that not focusing on competition can't bring these second and third order benefits.
can I just briefly say that, so a spectrum worker making, skilled spectrum worker making $55,000 a year in New York City, basically electrical line worker, after the merger, UBI is not an answer to that worker. But he is in a company town. So that's just an example of the ways in which workers in concentrated labor markets become deeply, profoundly dependent and chilled, and that UBI can't answer.
Alden.
Just a quick comment. I agree entirely. Hospital mergers are important. They have anti-competitive potential, but you have to also look at the structure, statutory structure. For example, there's some studies that suggest hospital concentration, including potentially anti-competitive mergers, may have been spurred by incentives created through the Affordable Care Act, for example. And it's not enough time to get into it, but a whole structure, regulatory structure, often, and the excellent point raised earlier about Noha and others, regulation being dangerous. There is a lot of heavy regulation of healthcare, and one of the problems of our system is that it's badly designed regulation. This is really associated with a lot of competitive problems. And yet the FTC did a number of studies of the system. Certainly competition enforcement is very important there, but you'd also need to look at some other statutory reforms as well to get rid of perverse incentives.
I just need to say for the record, I wish to be excluded from that narrative. Like,
Yes.
I did not say that all regulations.
I did not hear Doha say that regulation was a problem.
No, but we did hear Alden say that good regulation, well-designed regulation is good, right? So we have made some progress. Yes.
Very limited.
Please.
Just quickly, I want to say I overwhelmingly agree with Fiona that when a company gets too big, it should be broken up, that we should be preventing companies from becoming conglomerates, because if you want to have better enforcement, you have to see the problems. You have to have the ability to look at the information. The public, academics, et cetera, have to be able to see the information. And when a company like Amazon gets too big, you cannot see the information because nothing is material. Nothing rises up to be big enough to capture anyone's attention. Berkshire Hathaway, Amazon, you name it, nothing is disclosed because the materiality principle in securities enforcement, et cetera, says they don't have to even tell you about it. There's no segment reporting, the accounting, the audit, nobody pays attention to it, and lots of big numbers and big problems go completely under the radar because the company is so damn big that nothing rises to the surface.
So let me just say that wasn't what I was saying in my comment. What I would like to highlight is that if we have a political issue with companies being large, I think it's best dealt with by a law specific to that problem rather than trying to change the antitrust laws, which I think I agree with Doha, they should focus on competition. If we think we are threatened by a company's actual just physical size, economic size, then pass a law saying you can't be that big. That seems like a very straightforward, clear thing. And then as a democracy, we could decide if that's what we want to do or not. But that's distinct from enforcement of the antitrust laws.
I actually don't agree because in many situations, size comes, especially size in a particular sector, regardless of what is the price, etc., has a huge impact on the ability of companies to capture the entire system.
You're thinking about media, and there are many countries that have special laws about
not just media. Think about Boeing's ability to capture the regulator. I think that, or my experience in Italy is all corporate lawyers are beholden to 2 or 3 corporations, because if you want to have a law practice in Italy, in corporate law, you have to have big corporations as clients. And so even if you hire them on the other side, they don't work for you because their long-term interest is to work for the corporation that give them the repeated business.
And then
so
no one can go against them. No one can go against them. No whistleblowers, no independent private plaintiffs. No one can go against them when they get too big.
The only advantage to come from Italy is you have seen these things sooner because it's a small country and they are all in bed with each other, literally. And so I think that you see these things earlier, but later the United States seems to copy. It's like Trump is a copy of Berlusconi. So I had an early insight thanks to Italy. Anyway, Matt.
No, I think you're understating Italy. Italy also produces great disaffected economists. So just want to say that. I have a kind of a legal methodological question because you guys talked about market definition. There's another area of law where market definition is really important, but it's handled completely differently, which is anti-dumping countervailing duty law, where the International Trade Commission simply defines markets. They don't allow all of this nonsense in courts, and they just go and they look at commodities, they look at imports, and anti-dumping countervailing duty law is basically predatory pricing. It's done by foreigners. It's an administrative process. Happens at the Department of Commerce, the ITC, a couple other agencies. There are clear deadlines, so nothing ever stretches out for years. And it was set up roughly at the same time as the Federal Trade Commission. But the Federal Trade Commission and antitrust law took this really weird, sort of dumb detour out of the rule of law, whereas AD/CVD law is pretty administrable. So I wonder if there might be a way to think of antitrust law as just kind of an administrative process where there are appeals, but essentially it's just kind of like you have a bunch of nerds sitting in a government office just calculating market definition instead of these just millionaire lawyers who just extend things for years. So that's kind of one question. The second question is something Doha said, which I thought was really important and interesting. It gets to the rule of law itself, which is that enforcers in courts have just kind of ignored the plain statute of the Clayton Act, just don't enforce exclusive dealing provisions, predatory pricing, interlocking directorates. I would add Robinson-Patman. They just said, we don't like that law, we're not going to enforce it. It seems like that's kind of a crisis if you believe in this thing called the rule of law. And I wonder, what is the strategy, and I would sort of ask this to anyone because I'm not sure if you guys who can talk about it, but what is the strategy to actually say to the courts, no, Congress really meant it, and if you can't do that, then why would we assume that if Congress passes new laws saying, no, we really mean it, that that judges will care?
So I'll take the second question because I think it dovetails really nicely with an initiative that AAG Cantor has been really passionate about. I think all of you are aware of the whole of government approach and the fact that the agencies are dusting off the myriad competition statutes that exist, that kind of dot the U.S. Code, right? So we all know about the Sherman Act, we know about the Clayton Act, we know about the FTC Act, the Robinson-Patman Act, but there's the Packers and Stockyards Act, right? There's my personal favorite, Section 11 of the Panama Canal Act won't let you pass through if you've been convicted of a Sherman Act felony. I mean, it's like they're everywhere, right? And so, our view in the Justice Department is we can't wait, right? And we can't ask for permission from courts. We have to enforce the law as we see it. And if you see a problem, right, you are applying fact to law and you are duty bound to do so. And so, we are just now getting in, we're getting our feet wet, and I think you will probably see a ramp up in that kind of enforcement going forward.
Zephyr.
Oh, well, I mean, Matt just basically gave what I was going to talk about till Luigi kept saying we were going to talk about that later. But yeah, I mean, it's very weird. I come to antitrust from anti-corruption, and antitrust is different than every other area of law where it's weirdly accepted that you get to pick and choose which purposes and which laws people like nowadays, as opposed to the ones that were actually passed. It's very strange. And I would invite those who don't like the laws to engage in trying to persuade Congress and saying that's what they're doing, as opposed to trying to persuade courts. Because I do think that when economists don't recognize the illegitimate role they play, then it actually gives the courts more authority when they continue in that illegitimate role. So economists should say, stop, enforce the law, because unfortunately the judiciary is looking at this.
I just have to say respectfully a few words about anti-dumping law. You're right, it's there, it's implied, but it's imposed huge costs on consumers. It's also very anti-competitive. In fact, it allows domestic industry, including concentrated industries. Historically, a concentrated steel industry would put forth anti-dumping petitions. And the way cost is measured has nothing to do with the way economists think of cost. So what happens is you look at these accounting numbers, and they has been applied in a way so that competition was harmed. For example, there's lots of evidence out there that tacit collusion was facilitated in oligopolies in the United States due to successful or just the threat of anti-dumping petitions. So if you believe in strong, vigorous competition, it's on the books, but anti-dumping law has a very, very bad record.
I want the last word from Fiona. So are you in favor of applying the anti-dumping law? And given that you are in favor of giving direction to judges, should judge enforce Robinson-Patman?
I'm not going to answer those questions. I'm going to say that I just think that what Doha said about the whole of government approach cannot be emphasized enough. There are a lot of agencies that are not enforcing the competition element of their mandate, which is often actually written into their mandate. And there's ways to enforce the regulations that they have that would be considerably more pro-competitive. Congress is also needing to revisit a lot of these things. For example, we have supply chain problems in this country. I don't know if all of you realize that the shipping industry is legally exempt from the Sherman Act, and they run cartels, and that's not very competitive. And we have the Department of Agriculture not helping farmers, and we have the whole alphabet soup of banking regulators, as Anat told us yesterday, not making the banks perform very well. And so it really is a whole of government problem. And while it's fun to sit on a panel and talk about what vocabulary to change to give judges, the problem is much broader than that, and it's infused everywhere. And it's important to recognize that this is a big problem for the long haul, where a lot of different elements of government need to be pushing in the same direction.
Should the judge enforce Robinson-Patman?
Come back next year and find out.
Okay, so she's leaving us with a suspense. So thank you very much. This was great fun, and I have to say I learned a lot from the panel, so thank you for coming.